Who's Carlos Gomez? You're Carlos Gomez. Mr. Gomez, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Kasim, you are charged with racing on a highway and you are charged with unlawful carrying of a weapon. On the weapon case, you're facing up to a year in jail and or a $4,000 fine. On the racing, up to 6 months. As you, Mr. Rios, you're facing up to 6 months in jail and or a $2,000 fine on the racing case. Gentlemen, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
On February 1st, 2025, an officer who was part of a plainclothes traffic crimes task force was near Cross Timbers and East Texas Freeway in Harris County, Texas, where there was known to be a large street takeover group meeting. Officers in plain clothes were conducting a surveillance of the group of cars known to conduct the takeovers. The officer followed members of this group, specifically a gray Camaro, a white Camaro, and another Camaro. Officers witnessed the three vehicles slow down to 50 miles per hour and accelerate simultaneously up to speeds well over 125 miles per hour in order to outpace each other. Plainclothes officers were able to keep these vehicles in sight until marked patrol vehicles arrived and conducted traffic stops. Officers pulled over the vehicles and made an arrest.
So each one of them are in cars lined up?
Yes, Judge.
Okay.
Lane 1, lane 2, and lane 3.
Okay, so tell me about the gun on Mr. Kasim's case.
I'm sorry, Judge. What was the question?
So Kasim is Kasem. While you're looking at, gentlemen, I'm going to find that there's probable cause to go forward to the case. I'm going to tell you now, living in a city as big as Houston without the ability to drive blows. And I am now ordering you as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first thing I'm going to do is I'm going to put you in jail. The next thing I will do is I will take your ability to drive away from you. Do you understand? Not only that, the Texas legislature has made it extremely easy for DAs across the state of Texas to seize, take cars permanently for people who are continuously participate in these activities. And I'm telling you because I've seen it here where people get their $80,000 to $100,000 car seized and taken and they don't get it back. Do you understand?
Yes, Your Honor.
And Mr. Kasim admitted to having the handgun in his fanny pack to the officer.
So can you file those conditions on all these gentlemen? Or I guess let's go through each of them. Do they have Texas driver license?
They all have eligible Texas driver's license.
Great. All right. One more thing, gentlemen. You are not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, then you're not allowed to drive. If I find that you drive without car insurance or you violate any of these conditions, I will put you in jail. I will do everything in my power to protect my community. Imagine you hit something at 125 miles an hour. You crush anything. Do you understand?
Yes, Your Honor.
I will have you each take a seat while we craft your bond conditions. We'll have you sign it. Because you guys have lawyers, I will waive your appearances. So you don't have to waste your time coming to court, but you must stay in touch with counsel and they will tell you when you have to come back to court. If they tell me they cannot get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for your arrest. You become a danger to my community, I will issue a warrant for your arrest. Understand?
Yes, Your Honor.
All right. I'm going to have you each go to Victoria, sign a reset, and then we'll have you take a seat in the jury box.
Gomez?
And then if you can file all those and all of them. Thanks, Brent. All right, so Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading, credit for 7. Is this what you want to do, sir?
That I'm getting out tonight.
Yeah, it's time, sir.
So time serves is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand?
If our Salveria toll licenses does not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted and being in a judge's face like this again.
He's saying somebody doesn't want him to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
We are resourceful and knowing to not do it. So we don't
What do you
want.
say?
He said we are resourceful to knowing to not do it.
Okay, don't. You can get a felony next time. You understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences. It will go on your record. It will be there forever.
Just be like Salveria Toll Licensures. I am just be like I am the CEO of Salveria Toll Licensures, which means I am a lawyer.
Let's,
To understand that.
let me reset him, Judge.
We do not want to get in trouble.
Let's go back.
You're saying we do not want to get in trouble.
I want to make sure you understand, Mr. Edwin. Mr. Edwin, we just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir.
Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you will be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement. Be careful.
Okay, I need everyone to rewind that. Did he just say he's the CEO of Solaria to licensors, and that means he's a lawyer? I have so many questions. Is that a real thing? Is he representing himself? The judge's patience here is absolutely saintly. This is a perfect example of why you always have a real lawyer in court. This guy is pleading guilty and giving up his rights while seemingly operating on a completely different linguistic plane. This is courtroom chaos gold.
Don't run from police again. Okay? All right.
Good luck to you, Mr. Edwin.
Look, Mr. Edwin.
You're getting out today. All right.
You seem like such a nice guy. Why does this keep happening? Mr. Castro? Really? You're now charged with another assault. You're facing a year in jail and or a $4,000 fine. So what happened? Please.
On February 1st, 2025, approximately 12:43 p.m., officer was dispatched to Cypress Creek Hospital, Houston, Harris County, Texas. On arrival, officer met a complaining witness who stated she was assaulted by another patient. The complaining witness stated she was walking out of the room and the defendant started yelling at her, "Back up, back the fuck up." The complaining witness stated she was confused in a verbal argument. The defendant struck the complaining witness to her face, causing pain. The complaining witness had laceration on the inside of her upper lip. Police stated that they got into an argument and the complaining witness got into a fighting stance. The complaining witness won't get his hands.
Mr. Castro, don't go back to this hospital. Do you understand, sir?
Yes, I guess. I'm not allowed back there. I don't much have anything off that hospital that happened with that.
I don't want you to pick up any new cases.
Yes,
Nice.
I'm continuing to do that today. But interestingly, I guess, though, you're lucky.
Listen, I'm giving you a lawyer. Just stay in contact with him. He's usually pretty good about staying in contact, okay? Don't pick up any new cases. I don't want to have to put you in jail, all right? Just be nice when you're out there. All right, we need him to sign conditions and then you guys are free to go, okay? All right. You mind filing that? Please, no contact with the complaining witness and no going back. You're on a deferred, the type of probation for an extremely serious case. I mean, it's about as serious as it comes. You're supposed to live with a halo over your head, you know? Don't say anything. I'm just telling you, you gotta live like you got a halo over your head. You've picked up a new case with us. Lori is asking me to give you a PR bond, and I think everybody deserves a chance. So I will give you a PR bond now, but I'm not going to play this game. If you continue to pick up new cases, if you're a danger to my community, I'm not going to keep doing this. Do you understand? Okay. The problem is that you've not made bond upstairs. So I don't know if you're going to be able to, whether they're going to give you a PR bond or one, I don't know. So I will give you one with us on our failure to ID case here, but be good. It's not hard. Be good. No. Tell Lori, just what you got to worry about is upstairs, not us. Just be good. It's not hard. Do you know when the felony
They
case is?
they haven't put a court date on there.
Actually, they have. 2/12.
Oh, okay,
Next
so
Wednesday.
Wednesday, and I'll reset you until the Tuesday after that.
You want to do the next day, perhaps?
Okay, we can do Thursday. All right.
All right. And we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are appear in court every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a scram analyst as well. Correct?
Yes, Judge.
Okay, so
Yes, Your Honor. So,
yes,
yes, so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that, you can just,
no, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
it wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being, accused of DWI, wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but
Yeah.
sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the Scram device.
We have Fleischer that can be called up as a witness to testify as to what happened with, and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did
So.
that. So that's, yeah.
Please.
Yes, Your Honor, we would call retrial services, Ms. Felicia Choas.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, I need you to recognize this.
Yes.
Can you tell us what this is and what are the conditions that are checked?
These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain. We do have a curfew of 9 p.m. to 6 a.m. and then a Scram device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the Scram device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a Scram device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on Scram?
And I was not trying to establish her as an expert, just from her experience, what the Scram device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, State, or she's just reviewing? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we want to see, it's exhibit 6. Can you please tell us what this is?
So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts a scram for anybody that says this.
Yes,
We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
yes.
Defense received, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, sorry, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you, we pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So
number that was provided.
let me, sorry, that was a poorly phrased question.
I'm sorry, I
No,
don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No,
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
no,
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago
Mhm.
to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but
And
not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper,
Mhm.
environmental factors versus
Mhm.
consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so, one second. So is it fair to say that you've been thoroughly trained on the theory of scram device and alcohol detection?
What do you
Is
mean?
that fair to say? That let me rephrase that. So, you don't have any actual technical experience with how the scram device detects alcohol in someone's skin. Is that fair to say?
Think?
I don't want you to think. It's a yes or
I
no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a scram device works, or have I not for myself and?
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, uh, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I
We
partially
did
wrong
go
about?
over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially as well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are
Mhm.
worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no like, withdraw that question. So I'm just saying there was no like actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
And also reviewed some of the peer reviewed articles.
well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? You agree with that statement?
Yes.
Okay, so without actually having examined uh, in your own personal observation, how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just ask the question. I don't know if that was an objection or sustained
I mean,
or overruled.
let's just move on. I mean, we're here to see, is there a positive blow or not? She's
All
testifying
right,
that
it's
there
the-
was.
Sure. I'm just saying that this, all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scrum device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scrum device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scrum device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated those orders, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case?
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just taking into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well.
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it, you know? At some point, I become an enabler.
Boom. The hammer finally drops. This is a massive moment. The judge gave him chance after chance after chance, 3 bond violations. The defense attorney put up a valiant fight, arguing about the science of the scram device, but at the end of the day, the judge saw a pattern he couldn't ignore. An open DWI in another county? A positive blow for alcohol? A positive test for THC? This is what no tolerance looks like in action. The lesson here is crystal clear. When a judge gives you a lifeline, you do not test its strength.
And I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond, would you consider raising it to?
Well, I am gonna raise it, right? I'm gonna raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. He has every intention of taking this case to trial. So I would, just, I'm not Chief Your Honor. So if you could keep that into consideration on that.
And it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Okay.
Yeah.
But tell him this, that he's lucky that they didn't revoke him on the first two cases, considering that he has an open, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't. Mr. Gutierrez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Sir.
On January 31st, 2025, it says the officer observed a Dodge Challenger run the red light in an attempt to make a U-turn in a sudden acceleration and almost strike a vehicle that was traveling north and had a green light. The vehicle had to perform an emergency maneuver to avoid the Dodge, but did not stop and continued northbound on Westlake Houston Parkway. The officer initiated a traffic stop. And the defendant was pulled over for reckless driving and running the red light.
So you said he's at a stoplight?
Yeah, so he ran the red light in an attempt to make a U-turn while somebody else had a green light and almost struck the other vehicle. And he
Okay.
also had 0.20 grams of Tylenol on him. That's what the DIN says.
So I'm going to find probable cause now. Do your diligence, get the video. If you show something different, come back, let me know. We can always revisit probable cause at a later time. Okay. Do you see whether he has a Texas driver license, please? Okay. Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to drive in a reckless manner, no racing, street takeovers, donuts, anything of this manner. If I find that you do, or you put my public in danger, I'm going to revoke your bond, put you in jail. So you understand? Yes, sir, I do.
Eligible judge.
Okay. Now he's on felony probation upstairs. Are you familiar with this?
Not with the felony probation judge. Does it show they filed
He's,
a MAJ yet?
I don't know. Let's look. You're on probation. It looks like you may be a second or first degree felon. Yeah, second degree felon. So just be on the lookout, it's very well, they may file a felony warrant now. He's already had one MAJ dismissal. So be on the lookout, sir. Sir. So do you mind filing those conditions, please? All right. You're also, Mr. Gutierrez, not allowed to drive unless you have valid liability insurance in your name. If I find that you drive and you don't have car insurance, likewise, you'll end up going to jail. You understand? Now you have a lawyer. Because you have a lawyer, I'm going to waive your appearance, but it is your responsibility to stay in touch with Mr. Henderson, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for arrest. For now, I'll have you sign a wreath of Victoria. We'll have you take a sit in jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys.
Just you?
Got it.
All right. You can adjourn.
Good morning, Mr. Concepcion. So you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. Is it on docket today or no?
Not on docket.
Okay, that's what I was, okay. So it's a straight probation as well.
It is, Your Honor. I asked for deferred, but we settled on straight. He's on deferred on a felony.
Perhaps that's why. All right, let me see.
He did miss court a few weeks ago, Your Honor, so there was a warrant.
Is there a felony warrant right now?
Yeah, there should not.
Sure.
They reinstated his probation on the 9th of January.
And he has been meeting with his probation officer.
You need to understand something, that you're on probation for an extremely serious case. You're looking, is it a first or second degree?
Oh, second degree.
I think it's second.
Second degree.
You need to understand, these types of probations, when you get revoked on a second degree, you're usually looking at double digits, probably 10 to 12 years in prison. Do you have any clue what they would do to you in prison? No, you don't. Have you been to prison before?
Sir.
Your potential fit, how many times have you been to prison? Once, twice?
That's
You could
once.
be a potential 15 to life case from now on, man. You know, really. Not only that, it's a 3G. You get revoked, you're doing half the time before you're even eligible. There's only so many times that they're going to reinstate before they start throwing the book at you. You know what I mean? Really.
Yeah.
So you've worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 6 months. As part of the agreement, the only thing that you have to do is stay clean. Literally, it's the only thing you got to do. Can you do it?
Yeah.
If you don't, I'm going to put you in rehab myself. You know, really. Not only that, but depending on what you're taking, you take too much of it, all you're going to do is put your lungs to sleep and you end up dying. We see it happen here all the time.
Sure.
You build up that tolerance, you keep taking it, and then, you know, you're chasing it, right? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no changing. You understand?
Yes, sir.
This is what you want to do. You know, I got to figure of all your criminal history here, I wonder how much of it is related to, you know? You're young, get off, do something else.
I just turned 30 years old.
Really. And this,
Yeah.
all right, how do you plead to the offense? Guilty or not guilty?
I'm
I'm going to find you guilty. I'm going to send you to the agreement. If you want any help, come back and we can help you out. All you got to do is ask. But if you go out there, if you take off, you pick up a new case, you test positive, I'm going to put you in jail. I'm going to issue a warrant for arrest. We're going to bring you back. We're going to have a hearing. And if they prove it to me, you're looking at a year in jail. Do you understand?
Sure.
All right, man. Good luck.
Thank you, Your Honor.
Got it. Are you Miss Somali Lerner?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas, without proof of financial responsibility. Vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver ID'd by Texas driver license stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood, search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay,
And your driver's license.
great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischer for your bond conditions and then I'll have you meet with a lawyer. in a bit.
Her license being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly.
I need to start working. I lost my job.
Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay? Please. Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
Do not have story about that right here. On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. Defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. Defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately. That's.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything, because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay? So understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test you. And you're going to have, do you show a Texas driver license?
It's all good.
Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Fleischer, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this is from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants. And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, would be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it's so much baggage. He scares me, you know? And
he does have, he's kind of been a resident of this area, you know, for 25 years. So,
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this, you
understand, Your
know?
Honor.
So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know, so I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't weighed on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey, happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, R-I-L-E-Y.
Morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
What's a 2B? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know. So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, you know, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working, you know, if I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already, you know what I'm saying? So as soon as I go up there, he gonna walk me out, you know what I'm saying? I'm gonna take care of the bonding and everything. But I just wanna let you.
It's set there?
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, give you 14 days from the date of your release to go turn yourself in to Louisiana. If you fail to go do that, You have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Judge, we'd request a bond set of 1,000.
Big difference.
It's pretty big divide, Judge.
So the problem is also is that because you're a fugitive, right? You are an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make a
afford.
$1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
It's too low. I mean, that's what we do on normal cases, not just,
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, unless I get new
I
information.
don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500, okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have
We
able to
thought-
reach out to your folks, your family, to see that's something that whether you guys can make it. And
Under 2,500.
this is not I'm not going to negotiate with you, dude. It's just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding counsel and the court is that even presuming that he's able to make this, because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond into work. If that's okay with court.
2,500, like,
Don't argue with it.
no,
Okay.
no, I'm not arguing. I just want.
Here, look, let's do this.
My job and everything.
Let's
sitting
do
here
this.
14
Let's do
days.
this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dane. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the
So
complaining
my
witness in the
understanding is
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 8/10 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. You know, when you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. You know, now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still gotta go to rehab?
We'll talk about that.
We'll work through all the, I guess, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence, and the way that I do that are with these devices, you know, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Shriver's been living in a hotel. They've abided strictly, even with their communication and transportation today, with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of council's represented, and you know, we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives.
Man, that might be the most real, off-the-cuff life advice you'll ever hear in a courtroom. So many people develop horns when they drink. He's not just judging the crime, he's diagnosing the root cause. And his solution is equally direct. If that's you, the solution is simple, stop. He's being firm but almost compassionate here, pairing the ankle monitor with the offer of rehab. He's trying to protect the victim and save the defendant from himself. It's a tough balance. What do you think? Is the court's approach here fair, or too lenient given the new assault charge?
So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues?
That's why I'm going to rehab, sir. Yes, sir. I understand.
You know, there are people in life when they drink, they're very happy, they're the life of the party. Yeah, and then there are people who develop horns when they start drinking. If this is you, there's one easy solution. So what we'll do is I'll put the monitor on him. I'll waive the fee. Okay. I guess, correct. No alcohol, no drugs, random testing, no weapons, no threatening or harassing contact with the complaining witness, the scram monitor, waive the fees. Get with me as far as the facility and what they say about him having the device on, and if they're okay with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just.
We'll get a reset, maybe 45 days out, should give us enough time.
Do that. I need proof though. Like, get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. feel free to get with Victoria so that way you can match up the date after you get the new date and then.
I have the paperwork. How do you want me to get that to the court on the?
If you want to email it to us, it's okay. Email,
Okay,
probably the easiest. That way you don't have to come in and waste time.
no problem. Yeah, I will get it to you right now.
And then just one more thing, always just CC Sebastian. That way they always have it as well.
No problem.
Okay, all right, guys. Mr. Castillo, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, an officer was working an extra job at Home Depot and was alerted by the loss prevention officer that the defendant had entered the store, putting multiple power tools in a basket and exited the store with unpaid merchandise inside the basket. The officer was sitting in a motor vehicle and observed the defendant exit the store beyond all points of sale and head north in the parking lot. The defendant entered apartments across the street. The officer observed the defendant pushing baskets and approached the defendant. The defendant attempted to flee. The officer deployed a taser and placed the defendant in custody. The total value of items stolen was $519.98.
Got it. All right, Mr. Castillo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go back to any Home Depot. Do you understand? If I find that you do, I'm going to revoke your bond, put you in jail. No more PR bonds for you. You mind filing that, please? Okay. Tell me, do you have the ability to hire a lawyer, sir?
Yes, sir.
You don't want to apply for a court appointed? I don't want to talk about the case. Do you want a court appointed lawyer?
I mean, I could get one, but if I hire a lawyer, then I don't need the lawyer you're gonna give me.
Sorry?
I'm gonna go ahead and get a lawyer for myself.
You don't want a court appointed lawyer?
No, sir.
Okay. If you have a problem and you're not able to, just come back, let us know, and then we can appoint your lawyer. I'm going to have you sign a receipt of Victoria. I'll have you take a seat in the jury box. Let me get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Thank you, sir.
Don't pick up any new cases. Behave yourself.
Yes, sir.
You understand?
Yes, sir.
Okay, man, come on. Ms. Garay, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk and turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Garay, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an interlock for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand? And you have a great lawyer listed to Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand?
I do.
Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand?
I do.
All right. So I'm going to have you sign a receipt, Victoria. We'll have you get Fleischer for your bond conditions, and then you guys are free to go. All right. Thanks, guys. Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, sorry, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle and the officer was performing a felony stop on the possible stolen vehicle with multiple items in her hand. And the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of. The defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the patrol vehicle, to which the defendant refused and had to be escorted by force. The defendant kept moving her hands away from the officer and he attempted to handcuff her again. The officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
She the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop. Ma'am, don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm going to find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. Do you understand? Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it and then we can appoint you someone later today. Do not leave until you sign our bond conditions though, ma'am.
Yes, sir.
All right? Okay, please.
That's it, Judge.
Got it. You're Adam Reyes. Mr. Reyes, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of State Highway 6 turning left at a high rate of speed. The law enforcement officer made a U-turn at intersection and followed both motor vehicles, having to travel approximately 66 miles an hour in 40-mile-an-hour zone. The officer observed motor vehicles to be side by side with the Honda flashing emergency lights. The law enforcement officer observed Honda turn off the lights. Both motor vehicles began to speed up again while driving side by side, and they ran a red light. The officer attempted to catch up with both motor vehicles, causing the officer to travel approximately 90 miles an hour in 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. Traffic stop was initiated. The officer made contact with defendant, driver, the sole occupant. The defendant stated when asked about high rate of speed, "No, I was on my way home with my friend Adam, and Adam was following me home." Co-defendant arrived claiming he was there to check on the welfare of defendant. The co-defendant stated, "I was following him home, but I broke off because I wanted to get something to eat." Defendant ID'd with a Texas driver's license.
And Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in this type of activity again. If I find that you do, I'm going to put you in jail and then I'm going to take your ability to drive away. Do you understand? Can you look to see if he has a valid Texas driver license, please?
Yes, Judge, eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Reyes, or did you want to apply for an appointed lawyer?
I'll hire one.
Okay. I'm going to have you sign a receipt, Victoria. I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Be safe in my city. Do you understand? All right.
This way.
Mr. Thornton, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, the complaining witness and the defendant are in a dating relationship. And on December 18th, 2024, in Harris County, Texas, officers were dispatched to an assault call at a hospital. Officer arrived and made contact with the complaining witness, who stated that she and the defendant are in a dating relationship. Complaining witness stated that earlier in the day, she and the defendant were in an argument due to the complaining witness telling the defendant that he needed to leave the location. When the complaining witness got up to leave, the defendant pushed her through a wall, causing her to crash through the wall, causing pain. Officer observed the complaining witness to have a laceration over her right eyelid, swelling and bruising.
What's the problem with this case? You know, it shows it's dismissed. Something went wrong. Something's wrong. I'm showing that the case is dismissed when it shouldn't be.
This is Thornton, Judge.
Yeah.
My suggestion yesterday.
Or is it? I don't know. I don't even,
It is a DVD case, Judge.
Mr. Witness.
I don't even see a nollie.
For Thornton, it's not published, Judge.
Judge.
I mean, ready to publish.
Judge, you said he spoke with Chief Campbell, was dismissed for missing witness due to.
So it is dismissed then, right? Okay, your case has been dismissed, believe it or not. Just be careful out there, you know? Just, today's your lucky day. Count it, all right? Okay, man, good luck. That's okay, I did too. I'm just, I don't even see a copy of the dismissal here. That's why I was kind of, threw me for a loop, but Gabe knows, you know?